Hi, everybody. Welcome to another episode of Tax Sale Insiders. I'm your host. I'm Brian Seidensticker. I'm CEO of Tax Sale Resources. With me today, I got a repeat customer or expert, probably better explanation of Scott Walter. He's an attorney based in Missouri. He's done an excellent job kind of talking in the past about how Missouri statutes work, how the process works, some upcoming legislative changes. And I guess, Scott, welcome back. Thanks for joining us.
Yeah, thank you for having me, and I really appreciate the opportunity. It's always good to talk with you, and welcome everybody, and I guess happy Thanksgiving.
Yeah, it'll be here before we know it, won't it? I guess just to jump right into it, I mean, the hot topic of the day, which I think I always joked about, hot topic in the tax sale space, but it actually legitimately exists these days with the whole Tyler versus Hennepin County Supreme Court case. We'll just kind of jump into it. Obviously this has potential ramifications in many states. And I guess question one would be like, what does this mean anything for Missouri, and where do we go from here?
Well, a little bit of a spoiler here is that I think the ultimate conclusion that we get to is that I think Missouri is safe for now until things change or until things go, the next case perhaps takes it further. Okay, but in order to understand that conclusion, let's unpack it a little bit. When we're talking about Tyler versus Hennepin County, the Minnesota case went up through the Eighth Circuit, which Missouri is in the Eighth Circuit. So, of course, we were following it and aware of it and curious to see how it came out. Now, I will also say that Minnesota statutes are quite a bit different than Missouri as far as how a tax sale works. But the fundamental premise of the surplus and whether or not there's a constitutionally protected property interest in the surplus, that analysis I think would largely be the same, although Missouri statute treats it a little bit differently, because the thing that they seem to hang their hat on, Justice Roberts in the majority opinion, is that there was no opportunity for the tax debtor to recover the equity. And they kind of use the term equity and tax sale surplus interchangeably. We typically think of a sale or a foreclosure sale, whether it's a deed of trust, a mortgage, or even a tax sale, that it's going to be sold for fair market value. We kind of know that's a little bit of a fiction, but it's the best we can do. So we talk about that surplus as being like the equity. It's whatever is over and above the actual value of the tax lien. And
Right.
so that whether or not there's a property interest in that sort of hadn't really been addressed. And Minnesota was essentially arguing that there was no property right in that tax sale surplus because we said there wasn't by statute. And Justice Roberts said, yeah, well, we don't just look to state law to define property rights. We also look at like our history and traditions. And so that was a bit of a sea change for us. We always just thought property rights were strictly defined by state law, by state statute, and we can make them whatever we want to. And the Supreme Court said, yeah, but we get a little bit of a say in that too. So that part of the opinion was very interesting as far as, wow, there's this whole different way we have to look at tax sales surpluses. Now,
Mhm.
in Missouri, you'd want to look at Chapter 140, Section 230, and that's where it talks about foreclosure surplus. Some people call it an over surplus or an overage, but that's where it talks about how that's handled. This has become more of an issue in Missouri lately. I believe there's more surpluses because some of the counties during COVID and since have gone to like online auctions.
Mhm.
A major county of which has gone to a silent bid situation, and the silent bid tends to create more surplus because you
Hmm.
don't know what other people are bidding. So Rarely do you find any more a tax sale certificate in at least that county where it's the bid was just for taxes due. We used to have that all the time in all kinds of counties, and there was no surplus. And now I'm finding more and more surplus because of the different ways that the auctions are being handled as opposed to a traditional, raise your paddle type of in-person auction. And Missouri statutes are kind of silent about what type of auction it has to be, so we think the collector probably has discretion to do it that way. So, back to my original point, Justice Roberts was talking about how there was no opportunity for Miss Tyler to claim the surplus. And if you look at and they go through a lot of the history of various states about whether or not they treated that as a protected property interest for purposes of the takings clause, and they found that they did. They actually found that there was 3 states where that was not the case. Maine, but only for a very short period of time before they changed it by state statute. Mississippi, also for a very short period of time before their state Supreme Court overruled it. And then Louisiana, where they said, yeah, it's kind of on the books, but they don't really do it that way. They don't really enforce it. So they go back into talking about the Magna Carta and how this foreclosure idea, well, first of all, taxation itself is not unlawful. And even the seizure of property, like even real property, is not unconstitutional in and of itself. But what do you do with the extra if the bid goes over? And that's where they go through this history and they find, there is a protected property interest here. They distinguish a case out of New York, which the Hennepin County was arguing that favored them as far as unpaid water bills and things like that. They also try to argue that essentially Miss Tyler had abandoned her property by failing to pay the taxes, and he wasn't buying that either. He said basically, our law, most abandonment laws typically require some sort of overt act to show intent to abandon, and the non-payment of taxes in and of itself really isn't enough. Of course, Ms. Tyler also had not paid HOA liens and a mortgage on the property, but they said that's a belated argument. You didn't really put anything in front of the trial court as far as that goes, and so they glossed over that part of it and sort of rejected it. And I have held on to the last sentence of what Justice Roberts says: the taxpayer must render unto Caesar what is Caesar's, but no more. And so that's kind of where we're at. Now, let's apply this to Missouri with that basic understanding that somebody paid too much or paid over the amount of the taxes, penalties, and interest. By the way, they said penalties and interest, you're allowed to do that also. But the amount over that, okay, what do we do with it? Well, in Missouri, there is a relatively short period of time where people can file claims to it. So the tax sale surplus, first of all, it doesn't really become a surplus until the collector's deed is issued, and that's typically 1 year, give or take, but plus perhaps a few weeks, just depending on how long it takes them to process the applications and get them recorded. But that surplus is going to stay in there for at least a period of, I believe it's 90 days. I'm going to check that right now. It is 90 days. That's 140.230.2. So at least a period of 90 days and up to 3 years. And it depends on who makes a claim and when. And you have to make a claim in writing. Different collectors have different ways you can go about doing that, or forms that they require. Okay, but you get 90 days, which is a relatively short period of time. But I think the thinking there is that you've gotten notice from the county that your property was going to tax sale, which in Missouri, it can go to tax sale immediately after the first year of delinquency, but typically doesn't go until the second year or the third year. And I think we started to see that period get elongated during COVID. A lot of the counties that were at 2 years, I think, went to 3 years. So you've got this 3-year period of delinquency. You've got the tax sale certificate, and you've got a 1-year period of redemption, and you've got notice before the tax sale certificate or the tax certificate sale. You've got a notice during the redemption period, right? So you've kind of had some time, and you've gotten a bunch of notices in theory. That's not always quite the case, and we litigate those issues. But in theory, you've had plenty of time and plenty of notice, and now they've issued the deed, and let's say you're ready to make a claim for the surplus. Now, a couple things about that in Missouri. Number one is that a claim to the surplus, I think there's pretty clear case law out there that says a claim to the surplus is a ratification of the sale. So you don't want to go claim it unless you're okay with losing your property or losing your lien interest if your lien interest is one that is extinguished under Missouri law. Okay, so within that 90 days, you'd want to file your claim. Now, it also, those statutes also provide priority to certain other parties. And here's the sentence in subsection 2 under 140.230. The surplus shall be first distributed to the former lien holders of record by priority of the former liens, if any, then to the former owner or owners of the property. Lien priority shall be set as of the date of the tax sale. Okay, so it doesn't really matter what happens after the date of the tax sale, what happened during the redemption period or whatever. If you had a mortgage on your property and your mortgage company does not redeem, they could choose to then go make a claim to the surplus, and they would have priority over the homeowner. This is not something that was addressed by Tyler versus Hennepin County at all. Tyler versus Hennepin County basically just said, look, there was no opportunity for Ms. Tyler to claim that surplus after the sale was completed. The state tried to argue that there was an opportunity for her to sell her property and kind of beat them to the punch on the foreclosure and then pay her taxes, and then she could have sold her own property and kept her own equity, and the court was like, yeah, that's true. She probably could have done that. Yet she still has a continuing property interest in the equity in her property. So it wasn't good enough to just sell the property and keep the money to yourself. Okay, so in Missouri, we don't see a lot of lien holders claim tax sale surplus, unless perhaps you're a particular sewer district, which maybe shall go unnamed. So the tax delinquent homeowner who has now lost their property to a tax sale can go claim the surplus. I've seen it happen a number of times, and usually the court will, or sorry, not the court, the collector will just wait the 90-day period, and if nobody else has made a claim, they issue a check, and it's done. If the homeowner doesn't make a claim to it, then in theory it would stay in the county coffers for a period of 3 years. And then here's where Missouri might have a little bit of a problem, because after that 3-year period, Missouri, sort of similar to what Hennepin County was doing under Minnesota statutes, is that it escheats to the school fund of the county. Now, in Hennepin County, the Minnesota statute provided, I think the statute provided this, or they just did it this way. It was split 3 ways, I think, between the state, the state, the county, and the school district, or the split between the town and the school district. So they split it up somehow among various taxing entities. In Missouri, they don't do that. It would escheat just to the school fund of the county. I have heard people talk about attorneys and colleagues of mine in the industry that say they think even that's a problem, because that is still a taking of property that belongs to the homeowner. And so at this point, you might be saying, okay, well, what else are we going to do with it? Is it just going to sit at the county forever? Well, no, it doesn't necessarily need to sit at the county forever. They can do the same thing that we do when we have property that we know belongs to others, but we can't find them. We turn it into unclaimed property, and it will sit with the state treasurer, basically in perpetuity until somebody makes a valid claim to it. I presume that the state treasurer has some way at some point where it would escheat to the state, but could we turn it into unclaimed property? Yeah, we could, because I think what Tyler versus Hennepin County stands for ultimately is that the taxpayer who lost their home, that's their equity, and they have a protected property right in it. I think what could cure this potentially for Missouri is because think back to what the takings clause actually is. It doesn't say that they can never take property that belongs to you. There's certain situations where a government can take property that is that belongs to you. But there has to be at least constitutional notice and an opportunity to be heard and just compensation. And so, what else could the state of Missouri or the legislature do to fix this problem? I think there's a few things they could do, but I would suspect that maybe nothing will get done on that front until we have a case and there's a problem with it. Because I think what happened in Hennepin County is, it seems like they were careful to choose a proper plaintiff who was sympathetic, and we might have to wait until something like that happens in Missouri. But back to my original point, to begin with, I think Missouri is safe for now because unlike Hennepin County, there is at least some method for the tax delinquent owner who lost their property to claim that surplus. And if you go look at the case that they cite in Hennepin County, that Nelson versus City of New York, it's for all you attorneys out there, 352 U.S. 103. It was a 1956 case regarding foreclosure by the city of unpaid water bills. And in that situation, they actually did like what seems to me like a judicial foreclosure. I haven't gone back and read that case. I just am going by what they said about it in Hennepin County. And it said it permitted the owner to recover the surplus, but it required that they file a timely answer in the foreclosure proceeding. That makes me think it's a judicial foreclosure, asserting that the property had a value substantially exceeding the tax due. And the court found that that was sufficient because there was a method by which the person could go claim the excess proceeds. Okay. Mm-hmm. Now, to me, that could be difficult because somebody has to know that there's a suit going on, probably has to get an attorney to help them file something, and then probably has to have some basis to believe that the value of the property exceeds the value of the receivable being foreclosed upon, right? Well, in Missouri, I think the bar is a little bit lower. Really, you just kind of have to put it in writing, and you have to give them a copy of your ID that you own the property. You might have to do a little bit more to convince the collector that it's legitimate, the claim that you're making, but you certainly don't have to do anything as complicated as filing an answer in a lawsuit and claiming that the value of the property exceeds the value of the lien. So I think there's a pretty low bar in Missouri. Even though it's a relatively short 90-day period, I think Missouri is probably okay. And, if we're thinking about where people who like the result in Tyler versus Hennepin County, if we're thinking about where they might go next, they're going to look at states, of course, that are functioning similar to Minnesota, where there is really no provision for the foreclosed party to get that surplus back. And I think Missouri has enough there that they would be significantly different from that. So, you've heard, Brian, the analogy of where, there's a bear and there's two guys on the road, and the bear is coming up on him, and one starts to tie his shoe, and he said, "What are you doing? You can't outrun a bear, right?" He says, "I don't have to outrun a bear. I have to outrun you." And that might be what we're dealing with here. Missouri doesn't necessarily have to be perfect in this regard, but I think they're okay for now.
Got it. No, I think to kind of nail down the key components as far as I understand them, and I'm certainly not an attorney of the Tyler Hennepin case, is the fact that if there are a surplus generated, right, that surplus needs to at least be available to the previous owner, previous interested parties, right, for a period of time, right? And I think there's lots of things that weren't addressed in there. What is a reasonable period of time? Is even 3 years long enough? Is it forever, right? Those are all the questions, I guess, follow-up questions that come up. But the fact that Missouri's process, and I'll follow up because I know Missouri has a couple different processes, but the one used by most counties, one creates a surplus or has the opportunity of creating surplus, and the statutes allow for the previous homeowner or interested parties to claim that surplus. Then, in general, Missouri statutes and process meets the intent of what Tyler Hennepin is trying to say, versus what happened in Hennepin County, which is there was a surplus generated. the previous owner had no chance, right? The county kept it, they dispersed it, right? Sounds like between a couple different, but the fact that the previous owner had no ability to gain access to that equity created is what ultimately created the whole problem, right?
Yeah, and it seems to me like Minnesota does something similar to what Missouri does as far as like seizing land and selling it to pay the amount of the tax lien, but they just kind of front load it. Like they do a judicial foreclosure, and then they wait a period of 3 years, and then there was nothing after that. And I think part of the problem that the court had with that is they're saying, well, you don't really know the surplus amount until it's done, like until the foreclosure process is done. And that's why I made it a point earlier to say that a uh, even though there's an overbid at the sale that's showing on the face of the tax sale certificate, it's not really a surplus until the foreclosure is done. And that's the
Right.
first time somebody can make a claim to it. Because if it's redeemed, then the tax sale purchaser gets that surplus back without interest, and they get their taxes back with interest and all that. So um, I think I understand why Minnesota structures it that way, because it probably gives people more time. And when you go through the courts, in theory, it gives them better notice than like in Missouri where there's a non-judicial foreclosure process. But at the end of the day, they're going to have to go change their statutes to provide for some sort of opportunity for the person uh, to make a claim to that, such that their statutes comply with this Supreme Court's notions of the takings clause. We
Got
we
it.
also didn't really touch on the excessive fines issue, and this is where I was saying, Missouri could get in trouble with in its cheat to the state even 3 years later. And this doesn't really necessarily affect tax sale purchasers because at that point they don't really have a dog in the fight. The money's spent, they've got their deed, and they've gone. But Gorsuch, in the concurring opinion, along with Justice Jackson, would have gone ahead and found that it was an excessive fine and that it applies. One interesting argument I thought was when they said that, well, what if the amount of the taxes was less than the value of the property? Of course, we know that that's probably not ever going to be the case, right? But what if it were? Then they would get this windfall. And Gorsuch goes into this whole analogy. He said, well, some prisoners are better off, behind or better themselves behind bars. Some addicts credit court-ordered rehabilitation with saving their lives, but it's still punishment. And you can't punish people with these laws. It's still an excessive fine. And so if this, so there could be a situation where we could have a case maybe in the future that builds off of Hennepin County that says any attempt by the state to keep any amount over what they're due in taxes is an excessive fine. Now, the majority in Hennepin County doesn't go that far, but we know that there's at least two justices that would go that far. And the other thing we got to keep in mind is that Tyler versus Hennepin County was a unanimous decision. I don't think it would be that much of a stretch to think that they could find a few others to go along with them to say, anytime you keep it, that's an excessive fine. And then again, we're back to, well, then what else do you do with it? Only thing I can come up with that I've talked to other people about is unclaimed property, where it basically it does just sit with the state treasurer in perpetuity until somebody or a descendant of that somebody makes a claim to it. And there are companies that go around and try to, advertise and say, hey, you may have surplus funds or you may have unclaimed property. I get those from time to time, those solicitations. So, maybe somebody would claim it eventually, and maybe it would be the granddaughter or great grandson of whoever the foreclosed party was, and that would be a cool thing to get that money back to them. I mean, it was theirs.
Yeah, interesting. Well, it's I've talked to a few different attorneys in some states, and that's the first time that anybody's highlighted that component of it. But like you said, it could just be the follow up case. I think this is certainly a scenario that we'll be talking about for years, right? And so it'll maybe even decades. We'll see.
I wouldn't doubt it at this point. I mean, this was sort of I mean, you don't see tax sale cases get up even to like the the circuit courts of appeal very often, and this one, got all the way up to the Supreme Court of the United States. So yeah, obviously it's going to be a big deal, and everybody knows about it. And so, the people that like this ruling, of course, they're going to be emboldened to go try to take it to the next step or the next state, and try to impose their idea of what better policy is.
Yeah. Well, I know. So Missouri has a couple different processes that are used for tax sales. The majority of them use the process we just described. The lien is sold with a premium that is bid up, right? That premium is held by the county at the end of the issuance of the deed. Now that premium is what we've been talking about that
Yes.
the previous owner has right to. For the process that I think St. Louis and Kansas City use,
St. Louis
which is
County uses Chapter 140, just like we've been talking about. St. Louis City uses Chapter 92, and Jackson County, Missouri, where Kansas City, the urban core of Kansas City is, they use Chapter 141, and that's more of a judicial foreclosure process. And they do have hearings on like the value of the property and things like that. I don't quite know how it affects those because my work is almost exclusively limited to the, all but those two counties in Chapter 140. So maybe another
episode
we can get into.
Okay. Well, we won't dive down. My guess is if they're following, a judicial foreclosure process, right? There's a sale of the property. There's probably excess proceeds, and I guess we can revisit that. But
I would think the court would be awarding that back to the defendant as part of the final judgment, but don't quote me on that.
All right.
This is not legal advice, of course. Anyways, we're just talking. So, but yeah, I could look into that issue, and we could follow up again at some point. I'm sure there's going to be case law developments and maybe even statutory changes coming down the pipe in response to this. Although I haven't heard anything yet concrete about those sorts of changes happening in Missouri, but you never know. Sometimes they come out of the blue.
Got it. Okay. That answers my next question. Are there any planned changes as a result of that? Sounds like none today, maybe some in the future.
But so in Missouri, our legislative session is January through May of every year, and pre-filing begins December 1st. So sometimes we will start to learn about what is a priority for the legislature and what kind of bills are pre-filed in the first week or two of December. And that gives us a better idea of maybe what the legislature is going to be focusing on throughout the spring.
Got it. Okay. Well, Scott, I guess anything else you want to mention related to Tyler Hennepin today?
No, I think we covered it, and I just want to thank you for having me, and hope it was worthwhile for all the beautiful listeners out there.
Yeah, absolutely. Always appreciate your time and knowledge. Thank you very much. We'll talk again soon.
Thanks.
All right. Good luck, everybody.